Hello and welcome. This is module 28 and I am Professor Rashmi Raman. This module is titled Critiques of the International Criminal Court. As we always do in the modules that we have covered until now, let us begin with understanding why it is important for us to study this module. The International Criminal Court was created in order to help end the impunity enjoyed by perpetrators of the most serious crimes of concern to the international community at large. This was the first time that a permanent institution was established to bring the idea of justice and closure to victims and witnesses of war crimes, crimes against humanity, and genocide. This idea was in stark contradistinction to the other institutions established in the past, as unlike the International Criminal Court, they had been ad hoc criminal tribunals created to cater to a specific region, conflict or situation only. However, the International Criminal Court is not perfect, especially according to those states who have neither signed nor ratified the Rome Statute of the International Criminal Court and states that have no intention of doing so. In this module, we will look at the provisions and the practices of the International Criminal Court for which it has been criticized. The first ground of criticism is the exercise of jurisdiction not based on the consent of states. The inherent jurisdiction of the International Criminal Court, which does not require the consent of states parties to the Rome Statute, has been considered by many states parties and non-party states as problematic. There are three ways through which the International Criminal Court exercises its jurisdiction. A. When a state party to the Rome Statute refers the situation to the prosecutor of the ICC. B. When the Security Council, acting under its Chapter 7 powers under the Charter of the United Nations, refers the situation to the prosecutor of the ICC. Or C. When the prosecutor of the ICC initiates an investigation proprio motu on the basis of information of crimes within the jurisdiction of the court. The preconditions for the exercise of jurisdiction under Articles 13A and C of the ICC tell us that the court can exercise this jurisdiction when the conduct in question is committed on the territory of a state party or when a national of a state party is accused of a crime. On the face of it, there are at least two kinds of problems with this jurisdiction of the court. Firstly, and importantly, in relation to a state party, if an offence purported to be a crime under the Rome Statute is committed in the territory of a state party, then the court can have jurisdiction over the situation if a state party refers the situation to the prosecutor. It can be a state party other than the one on whose territory the crime has been committed or on whose territory the offences took place, because Article 13A is silent about which state party can refer a situation. The prosecutor then decides to initiate the investigation proprio motu. Secondly, in relation to a non-party state, the court can still have jurisdiction over a situation, and this works upon a referral of a state party or a decision of the prosecutor to once again launch a proprio motu attempt to initiate investigation. If a national of a non-party state commits an offence on the territory of a state party to the Rome Statute, then that person can still be subjected to the jurisdiction of the court. If a national of a state party commits an offence on the territory of a non-state party, from the language of the Rome Statute, it appears to be clear that the court does not require the consent of the state before exercising jurisdiction over a situation in the state party's territory or over its nationals. Some states are of the opinion that the International Criminal Court should investigate a situation and commence the proceedings against an accused only when the concerned state gives its consent regarding this. Unlike the International Court of Justice, which because of its positivist bias can only exercise jurisdiction when the affected states give their consent regarding the proceedings, the ICC appears to be able to commence proceedings so long as one state has ratified the Rome Statute and the crimes listed under the Rome Statute have taken place. Now, this is not appreciated by many states because international law as such has an inherent positivist bias. Many states do not appreciate the inherent jurisdiction of the court or the compulsory jurisdiction. And in fact, this is an idea that might discourage states from becoming a party to the Rome Statute. As a result of not too many states joining the Rome Statute, there is a serious threat that the universality of the court might be undermined. With respect to the exercise of jurisdiction over the nationals of non-parties, it is thought that by imposing obligation on non-states parties without their consent, the Rome Statute violates the principle of state sovereignty and in fact also the Vienna Convention on the Law of Treaties. The second ground under which the ICC comes for fire is the proprio motu powers of the prosecutor. As I told you in the foregoing section, the prosecutor can initiate investigations on a proprio motu basis, on the basis of information received on crimes committed, which are crimes within the jurisdiction of the court. The independent office of the prosecutor of the International Criminal Court is viewed with suspicion by many states due to the power given to it to trigger an investigation on its own. States consider it inappropriate to vest an individual prosecutor with the power to initiate investigations proprio motu, because according to states, the competence and the rightful authority to initiate the jurisdiction of the court should rest with the state concerned. It is also believed that the prosecutor of the ICC and the powers of the prosecutor to initiate this investigation proprio motu, this mechanism itself can be exercised without checks and balances. And so to protect against frivolous prosecution and to protect against making the prosecutor the judge in her own cause to rule on state conduct, states have been wary about this tool. Thirdly, the jurisdiction of the court in internal conflicts. The Rome Statute of the International Criminal Court provides for jurisdiction for internal armed conflicts for war crimes. The ICC's jurisdiction over the war crimes committed during internal armed conflict poses a serious threat to the sovereignty of states, to which the preservation and integrity of their nation comes first and is certainly above any obligatio erga omnes. The jurisdiction of the International Criminal Court in internal conflict has instilled fear amongst many states. States are concerned about the possible misuse of the court's jurisdiction in internal conflicts by a polarized or politicized Security Council or an non-independent prosecutor. Such an exercise of this kind of jurisdiction would severely undermine the sovereignty of the state. And so a lot of states have objected to such a wide amplitude given to the jurisdiction of the ICC. States have insisted repeatedly at Assembly of States Parties Conference on respect for state sovereignty and non-interference with internal affairs. States have stated that such kinds of cases should primarily be handled by municipal or domestic courts only, where justice can be dispensed more effectively and in a more true sense. Furthermore, states have argued that the inclusion of internal armed conflict within the jurisdiction of the court is actually inconsistent with international customary law on this point, because non-internal armed conflict do not usually qualify. Fourthly, the powers given to the United Nations Security Council. Most states have been furious over the vast powers given to the United Nations Security Council in the Rome Statute, in addition to those that it already enjoys under the Charter. States frequently cite this as one of the primary reasons for not joining the International Criminal Court. Apart from the power of proprio motu initiation of investigation by the Office of the Prosecutor or on referral by states parties to the Rome Statute, investigation can also be triggered when a situation where one or more crimes listed in Article 5 of the Rome Statute appear to have been committed and can be referred to the prosecutor by the United Nations Security Council. The Security Council has also been given the power of deferral of investigation or prosecution, under which qualifier no investigation or prosecution may be commenced or proceeded with under the Rome Statute for 1 year if the Security Council requests the ICC through the prosecutor to do so by way of a Security Council resolution. To give you an example of how states oppose this, Malaysia rejected the role of the Security Council in the Rome Statute, as it considered that any intervention by the Security Council could undermine the independence of the court, and so the political role of the Security Council might hinder the effectiveness of the process set out by the court. Another sovereign state, Pakistan, also opposed the role of the Security Council, since it considered that the decision of the councils were based on political motivations, and such political considerations cannot be the foundation for a legal principle to proceed with prosecution, since this would not be conducive to the development of a non-discriminatory and non-selective uniform system of jurisdiction. The Philippines feared that the court might become yet another tool for political domination due to the vastly important role given to the Security Council. At the conference of the plenipotentiaries, the head of the Indian delegation, Dilip Lahiri, said that the statute, that is the Rome Statute, gives the United Nations Security Council the power to refer, the power to block, and the power to bind non-states parties. All three are undesirable. India objected the existence of the power to block, as the court, which was created to try crimes of the gravest magnitude, would have to stop its ongoing proceedings if the United Nations Security Council so decided. According to the statement made by India, the role for the Security Council that has been built into the Rome Statute of the International Criminal Court sows the seeds of its own destruction. It has been said that the presence of such provisions in the Rome Statute, which favor the dominant will of a few states through the favoring of Security Council, will inevitably lead to a democratic deficit and a loss of faith which the states have in the neutrality of this court, and would hence impair its credibility. As the Security Council has, in practice, already used the power of its referral twice in relation to Sudan and Libya, the objections of states cannot be rejected on the grounds that this power would not be used. We need to consider the possible outcomes of this abuse of power. Fifthly, the possible approaches to the principle of complementarity are one of the obstacles to the popularity of the court. Under the idea of complementarity, which is foundational to the ICC would not replace national jurisdictions but will only complement it. Article 17 of the Rome Statute deals with the issues of admissibility. It says that the ICC can only admit a case if the state where the crimes happened is genuinely unable or unwilling to carry out the investigations or prosecutions. Thus, if the national law of a state is not adequate to accommodate all of the crimes listed in the Rome Statute, then that state might find its judicial system being taken over by the ICC because it is unable to accommodate the crime in its municipal system. But in the perception of states, parties and non-parties, they see that they will constantly have to prove the viability of their judicial system. It is true that a state might have to change its laws at the time of ratification. A new state party to the ICC from Asia, Laos, East Timor and Cambodia, had to change their criminal statutes and bring in constitutional amendments to make their municipal laws in pari materia with the Rome Statute. If a state wishes to exercise jurisdiction over the persons for crimes envisaged in the Rome Statute, they have to codify those crimes and incorporate them from the list given in the Rome Statute into their domestic jurisdictions. They then need to define those crimes under municipal law in the same terms as it has been defined in the statute. Failure of a state to do so would make it impossible for that state to prosecute a crime. And this impossibility would be interpreted by the court as a genuine inability of the state to investigate or lead a prosecution against a criminal. And this in turn would lead to the admission of the case into the realm of the ICC. The implementation of the Rome Statute into municipal law is proving to be more challenging than what the drafters initially thought it would be. And ineffective implementation of the Rome Statute can in fact deprive states of their primacy in exercising jurisdiction. According to Article 17, which is the complementarity article, 17(2)(b) talks about the unnecessary delay in the Rome Statute for giving justice and says that an unnecessary delay would be treated as unwillingness of the state and would strip the state of its primacy over crimes given in the statute, even if the state had in fact ratified and brought them into municipal law. It is a well-known fact, for example, that the justice delivery mechanism in India is very slow. It is a fact to which even the government admits. Thus, it would be quite difficult for India to join the International Criminal Court, since it would likely not be able to exercise its primacy over jurisdiction owing to the natural slowness of the criminal justice system. Thus, a potential member might decide that it is more prudent for them to refrain from joining because of the legal and constitutional amendments that they have to bring about in the municipal jurisdictions after the event of ratification. And in any case, the difficulty of doing it effectively enough to preclude primacy over jurisdiction, which actually is a disincentive for states to even join in the first place. Non-inclusion of terrorism and the use of nuclear weapons in the list of crimes. India and other states have heavily criticized the exclusion of terrorism and the use of nuclear weapons from the list of crimes codified and deemed criminal under the Rome Statute. Iran, Sri Lanka, Thailand and Vietnam supported this Indian stance that the use of a nuclear weapon should be listed as a war crime. Terrorism, as we have discussed in foregoing modules, has become a menace to mankind. The ICC could have been And in fact, many people saw it as becoming an important tool against terrorism at the international level. But unfortunately, because of a political impasse, it was not included in the list of crimes. Nuclear weapons are inherently the most indiscriminate. But even so, their use is not criminalized and codified under the Rome Statute. More than 15 years after the adoption of the Rome Statute, not much has been done regarding inclusion of terrorism and the use of nuclear weapons. Although the Netherlands and Mexico did propose suitable amendments to the Rome Statute in order to expand it to include terrorism and the use of nuclear weapons to the list of crimes, these proposals were subsequently rejected by the Assembly of States parties. Or seventhly, the applicability of bilateral immunity agreements. Under Article 98 Clause 2 of the ICC Rome Statute, the provision says that a state party may not be obliged to cooperate with regard to an arrest warrant issued against nationals of a non-party if there is an agreement between the state party and the non-state party not to surrender the nationals to the ICC. The states, particularly the United States of America, have signed the non-surrender agreements pursuant to this, and they have, through this mechanism, created something known as bilateral immunity agreements. Through these bilateral immunity agreements, they have undermined the authority of the court. The USA, for example, has signed bilateral immunity agreements with many states, wherein countries pledge not to transfer each other's military personnel or civilians in their jurisdiction to the ICC. Such steps taken by states consciously to avoid the landmine of the Rome Statute have seriously undermined the court's jurisdiction. The eighth ground is a very important one: the alleged victimization of African states by the International Criminal Court. Does the ICC have an anti-Africa bias? Currently, the situations before the ICC are the Democratic Republic of Congo, the Central African Republic, Uganda, Sudan, Kenya, Libya, and the Côte d'Ivoire. All of these states are from the African continent. In a meeting called by the Asian African Legal Consultative Organization, to which India is also a party, the ALCO, in Putrajaya, Malaysia in 2011, diplomats from the African states accused the International Criminal Court of targeting the African continent, and such an accusation led to insecurities present in the Asian delegation at that meeting, thinking that they might in fact be next in the series of victimizations. It should be noted that after the investigation in Kenya was approved by the Pre-Trial Chamber 2, Kenyan authorities tried to get the investigation deferred by the Security Council by passing a resolution, but that deferral never came through. Ever since the Kenyan episode and the failure of the Security Council to use its power of deferral in favor of Kenya, and simultaneously the issue of an arrest warrant against the sitting head of state of Sudan, President Omar al-Bashir, the African Union has consistently alleged the targeting of the African continent by the International Criminal Court. Owing to these factors, which are hard to argue against, even though there are some token cases outside the African continent in recent times, there has been a loss of enthusiasm for the ICC in Africa. In the recent past, the Kenyan Parliament had voted to withdraw from the International Criminal Court in response to the indictment and subsequent trial of the sitting President of Kenya, Uhuru Kenyatta, and his deputy William Ruto for their crimes against humanity. The African Union has also considered inciting a mass pullout of all of its member states from the ICC's Rome Statute. What do all of these steps tell us about the International Criminal Court? Despite its aspirations to universality, and in fact its aspiration to becoming a treaty that codifies jus cogens norms, the International Criminal Court is in fact far from popular. Not only is its popularity affected by the 8 grounds that I have explained to you, another serious consequence of the reluctance of states to sign and ratify the Rome Statute is that the jurisprudence of the ICC becomes limited in application. You will remember that this is quite different from the jurisprudence of the ICTR and the ICTY, which have been used extensively by states parties and in other tribunals. Each time that the jurisprudence is used, the strength of the court is reified. And absent this kind of support for the jurisprudence of the court, it becomes sketchy. I would like to conclude on a positive note to let you know that my thoughts are not entirely negative. There are reasons that the International Criminal Court has chosen to put its weight behind these 8 allegations. And in fact, a counter is possible for all of them. For example, in the sense of the African bias allegation, it is true that after 2012, the International Criminal Court has opened investigations in other parts of the world, including Eastern Europe. Now this, as far as the ICC is concerned, is a counter to the anti-African bias. However, it is not enough to counter the bias. And one might argue that there are political pressures motivating the International Criminal Court, all of which challenge its absolute independence. And this is the reason that we are choosing to deal and spend some time talking about why the critiques of the International Criminal Court are as important as understanding its operation, history, development and function. Thank you.